Elena has had her green card paperwork sitting in a folder on her kitchen counter for 3 weeks. Everything is ready. Her husband's job offer, their marriage certificate, the medical exam. She just hasn't mailed it yet because she wanted one more weekend to double-check everything. If Elena doesn't mail that folder before September 18th, 2026, the rules that decide her case change completely, and the form sitting in that folder right now won't even be accepted anymore. If you have a green card application anywhere in your plans, ready to file, halfway done, or still just an idea, this video is the one to watch before you do anything else. We're breaking down exactly what's changing on September 18th, why the filing date on your application matters more than it ever has, and the specific mistakes that could get a complete, honest application rejected without USCIS ever reviewing a single page of it. Let's start with what actually happened, because this builds on something we've covered before, and it's important to understand how it's evolved. On July 16, 2026, the Department of Homeland Security finalized a rule rescinding the 2022 Public Charge Regulation, the framework that's governed green card applications filed from inside the United States for the last several years. That final rule was published in the Federal Register on July 20th. The new standard takes effect September 18, 2026. Here's what that word, rescinding, actually means in practice. The 2022 rule was detailed and structured. It defined exactly which benefits counted against an applicant. It generally limited that list to cash assistance and long-term institutionalization at government expense. And it gave officers a fairly narrow, predictable framework to work inside. Starting September 18th, that structure goes away. Officers return to a broader, case-by-case approach, weighing what the rule calls the totality of an applicant's circumstances. That includes things the 2022 framework mostly kept off the table. SNAP, Medicaid, and housing assistance can now be factored in, not just direct cash aid. And critically, the government no longer has to be someone's primary source of support for their benefit use to count against them. Now here's the part that decides which set of rules actually applies to your case. And it's the single most important detail in this entire update. The filing date decides everything. If your Form I-485 is filed, postmarked, or submitted electronically before September 18th, 2026, your case is judged under the current, narrower 2022 framework, even if USCIS doesn't get around to deciding it until months later. If you file on or after September 18th, the new, broader standard applies instead, no matter how strong the rest of your case is. There's no gray area here. The calendar, not the strength of your documentation, decides which rulebook your officer is using. There's a second deadline hiding inside this same update that trips people up just as easily: the form itself. USCIS is releasing a revised version of Form I-485 to go along with the new rule. Starting September 18th, the older edition of the form will no longer be accepted at all. And here's the detail that makes this genuinely costly if missed. A rejected I-485 isn't a delayed I-485. It's returned to you, unfiled, as if you never submitted anything. If you're relying on a specific filing date to protect a priority date, maintain your status, or lock in a child's age under the Child Status Protection Act, a rejection over something as simple as using the wrong form edition can cost far more than the time it takes to refile. If you refile after that rejection, you don't get to keep your original filing date. The new date is the one that counts. And if that new date falls on or after September 18th, you're now under the new rule too, whether that was your plan or not. If you're finding this useful, go ahead and subscribe, because we're going to keep tracking exactly how USCIS implements this new standard as the September 18th deadline gets closer. Let's make this real with 2 examples, because the rule sounds abstract until you see how it actually plays out for 2 different families. Maria is applying for a green card through her U.S. citizen husband. Her family has used Medicaid for the past 2 years for their 2 U.S.-born children, and they also receive SNAP to help with groceries. Filed before September 18th, her case is reviewed under the current, narrower framework. The kind of benefit use in her situation generally isn't part of the analysis at all. Filed on or after September 18th, an officer can now weigh that benefit history as part of the broader picture, even though the benefits belong to her citizen children, not to her directly. That doesn't mean Maria's case is doomed either way. It means the kind of evidence that helps her looks different depending on which side of that date she lands on. Under the new standard, showing a path toward stability matters more than it used to. A pending raise, a finished certification, a spouse's improving income, anything that shows the family's situation is moving forward rather than staying fixed. Then there's David and his wife, adjusting status together while receiving Section 8 housing assistance. If they file before September 18th, that housing assistance stays outside the public charge analysis entirely, the same way it has for years. If they file on or after September 18th, it becomes part of the full review. Same couple, same documents, same honest situation. A different filing date changes what an officer is allowed to weigh. That's not a hypothetical difference. It's the entire reason timing has become the first question, not an afterthought, for anyone in this position right now. These two examples point to the same lesson. Nobody is retroactively guilty for benefits they used honestly under the rules that applied at the time. What changes is which rules apply going forward, and that hinges entirely on one date. A few more things worth knowing before we move to what you should actually do. This rule doesn't touch anyone who already has a green card. It only applies to people applying for a visa, admission, or adjustment of status, not to permanent residents simply living their lives here. It also doesn't reach into employer-sponsored work visa petitions, family petitions, or employment-based petitions on their own. This specific rule governs Form I-485 decisions and admission decisions at the border. Nothing broader than that. And several categories stay exempt from the public charge ground entirely, under both the old rule and the new one. Refugees, asylees, VAWA applicants, and a handful of other humanitarian categories. So what should you actually do if a green card application is anywhere in your near-term plans? First, if you're eligible to file now, and you're ready, filing a complete, well-documented I-485 before September 18th means your case gets judged under the current, more predictable rule. Second, don't rush a genuinely incomplete application just to beat the deadline. An incomplete filing creates its own problems, and a rushed case with real gaps can cause more harm than filing a few weeks later under the new standard. Third, if you or a family member on the application has used SNAP, Medicaid, or housing assistance at any point, start gathering the context around that now. A temporary period of help after a job loss, a pregnancy, or an illness looks very different next to records showing stable employment, insurance coverage, or family support. But you need those records organized, not scattered. Fourth, review your Form I-864, the Affidavit of Support, closely, since a missing or insufficient affidavit can make someone inadmissible on its own, separate from anything else in the case. Fifth, if you're not ready to file a complete, accurate application before the deadline, don't force it. Talk to a licensed immigration attorney about whether filing before September 18th genuinely makes sense for your specific situation, or whether preparing properly for the new standard is the safer path. Let's cover the mistakes people are already making with this news. Mistake 1. Assuming this is the same public charge story we've covered before, with nothing new to pay attention to, the deadline, the form change, and the rejection consequences are genuinely new details worth acting on. Mistake 2. Filing right before the deadline with a form edition that's about to expire, without checking whether USCIS has already published the revised version. Mistake 3. Assuming a rejected filing preserves the original postmark date, it doesn't. And refiling after September 18th means the new rule applies to you. Mistake 4. Cutting a U.S. citizen child off benefits they're entitled to, believing it protects a parent's case when it does nothing of the kind. Mistake 5. Waiting until the final week of the deadline to start organizing financial records and affidavits that realistically take time to gather properly. Here's the honest summary. On July 16, 2026, DHS finalized a rule rescinding the structured 2022 public charge framework, replacing it with broader officer discretion, effective September 18, 2026. Your filing date decides which standard applies to your case. File before September 18th, and the current rule governs, even if the decision comes later. A revised Form I-485 is required starting that same date, and older editions will be rejected outright, not delayed. If a green card application is part of your plans this year, September 18th is the date your entire timeline should be built around. Think back to Elena's folder sitting on that kitchen counter. One more weekend of double-checking doesn't sound like much. But depending on exactly which weekend that turns out to be, it could be the difference between the current rules and a broader, less predictable one. That's not a reason to panic and rush an incomplete application out the door. It's a reason to know exactly where the line is, and to make sure whichever side of it you land on, you got there on purpose. This video is for general information and educational purposes only, and does not constitute legal advice. It reflects DHS's published final rule and USCIS guidance, current as of the time of this recording, and additional policy guidance is still expected before the effective date. If you're preparing a green card application, consult a licensed immigration attorney about your specific timeline and circumstances. Follow for more updates like this one, and subscribe to the channel so you don't miss what's coming.